Welcome to the Meet a Mediator podcast. My name is Iona Zanke, and I am your host for this episode. Introducing today's guest, an accomplished attorney, mediator, and arbitrator with extensive experience in program management, facilitation, education, and training, Anna Cristina Maldonado is the Director of Externships at Nova Southeastern University Shepherd Broad College of Law. In today's episode, we talk about her journey as a mediator, her experiences successfully mediating over 2,000 cases, and her love for teaching. We hope you enjoy the episode. Cristina, thank you so much for joining me this morning.
Iona, thank you so much for having me.
I am really excited to get to be sitting here with you this morning and getting to know you. For my first question for you, can you share a little bit about your journey and what inspired you to become a mediator and pursue this unique career path?
I remember in sixth grade signing up for peer counseling and sort of realizing that, wow, this is a real skill. Listening is a real skill and it can help people figure things out. So if I were to track it back, it goes as far back as middle school. But as far as becoming a mediator, I used to live in Washington, D.C. After college, I was working in international, international development. And people I knew were going to graduate school, and I didn't know what I wanted to go for. But I ended up at a conference at George Mason University, and I can't remember who sponsored it, but it was one of the early iterations of like the Society for Conflict Resolution, with SPIDER or CPR, things like that. We're hosting this conference, and it was at George Mason. I went for this one day conference and just came away, wow, you can study that? That's amazing. So I got a master's in conflict resolution while I was working in DC. And then I moved to Florida, and in sort of the sort of mid 2000s decided to retool so that I could stay in Florida, not doing what I used to do for a living. And at that point in time, I knew about mediation and I knew about arbitration, having gone through the master's program. So I went to law school, and I thought to myself, well, when I'm done, I'll try to start there. So that was the path.
Thank you so much for sharing a little bit of your background with us. You shared that your initial degree, you got a master's in conflict resolution. Can you share a little bit about how that foundational work kind of prompted you into mediation, and if the kind of trainings that you have to do for mediation, especially in the state of Florida, how that kind of dovetailed into what you had to learn? Was it different? Was it the same? How did it help?
I didn't graduate from that degree thinking I'm going to be a mediator. I graduated, being aware of it. Many of my classmates were what I refer to as recovering lawyers, because not every state has a certification program like Florida does. And in a lot of places, the way you learn to become a mediator, especially back then, was to go to grad school and sort of retool that way. So it was, I've been at it for 15, 20, 25 years, and I am done with this litigation. I'm looking for a different way. Then in terms of, I thought I was going to stay in international development at that point in time. This was sort of the Iraq War was on. There was actually a fair amount of sort of international peace building work that I was very curious about. And that was where my focus was when I was going through graduate school. But when I came to law school, when I came out, law school has a way of sort of making you think that there's only like 2 or 3 jobs that you're supposed to do. Congratulations, you're now supposed to be a trial lawyer. So even though I hadn't really thought about doing that, I was still sort of thrust into that kind of situation. When I came out of law school, I was doing foreclosure law like pretty much anybody else in 2010, 2011. And at the same time, I was like, well, let me go back to the mediation side. So I started getting certified at that point in time. I got my circuit civil right around the time I graduated. So I was doing foreclosure mediations right out of law school. It was something that I used to pitch myself to the few jobs that were available. And then I started getting family certified in the aftermath, which led to my getting employed by the county in Palm Beach. the 15th Judicial Circuit as a family and dependency mediator a couple of years later.
So you've mediated over approximately 2,000 cases throughout the entirety of your career. What have been some of the most significant lessons that you've learned from handling such a diverse range of cases? And if you can also share, you covered this a little bit in the prior question that I asked, but what are some of the types of cases you've mediated? And then what are some of the most significant lessons?
So early on in my career, I did foreclosure mediation, I did family mediation, and I did dependency mediation, juvenile dependency, when the state intervenes and takes a child away from their family or places them with services. Then after being at the courthouse for about 4 years, I went out on my own. At that point in time, I started mediating more circuit cases, a fair number of insurance, personal injury, some commercial, some real estate, just a wider variety of just generic circuit civil cases. At that point in time, no real specialty. A lot of lawyers will come with a past experience in a particular area of law. So when they step out into mediation world, they're doing those types of cases because that's what they're most familiar with. I had this sort of generalist theoretical background, and it made me not afraid to handle different types of cases because I think of every case as completely unique, and you're just sort of applying the dispute resolution principles to trying to resolve it. But I do acknowledge that having more experience over time on a specific type of case makes you a little more versatile, I think, in terms of the creativity and the options that you can help people think of, trying to figure out what to consider as for their solution for going forward. So I love mediation because it's the only point in the process where it's the parties who get to have their say. At every other point, somebody else is in charge. And mediation is that moment where you're like, look, you get to do this. You know, for good or for ill, you get to make this decision right now. It's been really hard, but you have this chance. And I love that, being able to sort of hand that back to people.
And as you were starting your career in mediation, what would you say were some of the biggest challenges that you had to overcome when you were starting your career? And what are some of the ways in which you did overcome those challenges?
So trying to hang out a shingle as a mediator right after law school was very difficult. I don't think I could have made it work. In the end, I tried, but it was not something I could do without any kind of a base business. Even before going to law school with that master's degree and trying to pitch myself as a mediator, I had a hard time. There's sort of Florida is mediation is very integrated into the courts, and there's a lot of mediators are not attorneys, are coming from other different professions. But when for any case that's involving an attorney, there's going to be this bias towards the attorneys. And so if it's me versus somebody else who has a law degree, they would have been the person with the law degree that got chosen. And so in order to counteract that, I had to build up some really good, incredible experience in business relationships. And my time at the courthouse did that. I think I really built up enough of a reputation and connections with other attorneys who, when I left the courthouse and hung out my shingle, people were willing to use me because they knew me at that point in time. I was a known quantity. They don't like to be surprised with their neutral. It's like, my example is that it's like going to the grocery store and you walk past the cereal aisle with like 500 types of cereal and you pick Cheerios every time because you know what you want. Or maybe, like, okay, today we're going to switch to this one other thing, but there's maybe 2 or 3 cereals that you'll be willing to buy and everything else is weird and you don't trust it. So people are very skeptical in terms of who they allow to work on their disputes. There has to be some kind of a trusting relationship built up.
In your current role now, you have recently just joined the faculty at Nova Southeastern University Shepherd Broad College of Law. Congratulations as the new director of externships. How do you think schools or programs that help students become mediators would be able to help kind of share or mitigate some of the obstacles that you have shared in the prior response that you gave? Do you think schools would be helpful in working on that? Do you think certification programs? What part of the profession would help? Would mentoring? How do you find that we can help each other in that manner?
Florida is an open shop in terms of anybody being able to get certified. You do not have to be a lawyer to be somebody's mediator in Florida. In terms of mitigating the kind of I'm going to call it the bias, in terms of the sort of pro attorney bias in terms of the field of mediation. In my end of things, I try to enlighten the future attorneys who are coming through my hands that, just because you're a lawyer doesn't mean that you know it all, right? It means that there's a lot of other professions out there that can really add to it. And just as we as attorneys can learn from other professions, there are lots of people who are coming in from other professions who would make a good mediator or a great mediator, but they will need to have some understanding of that law. They're going to have to speak fluent lawyer as well, even if they didn't go to law school. So it's kind of a two-way street. You can't, if you're dealing with the mediation inside the legal system, you can't get away from the fact that there's legal implications and understanding that's involved. But you also have to step away from the thinking that that's the only way to do it, right? So many times when you're training lawyers to be mediators, they're like, but that's not the law. You're like, yes, but that's what these parties agreed to, right? So you kind of have to practice getting out of your own way. And in terms of you spend all this money and all this time learning all this knowledge, and now we're asking you to set it aside. In a world where I'm going to just sort of ballpark it, there's no exact number, but it's like out of every 10 cases, less than one goes to trial, right? 9 and whatever are going to resolve in some other different kind of way. And just building an awareness about that into a future attorney, and just a growing awareness, not just about mediation, but sort of the other different doors in the multi-door courthouse, right? Just the different ways that you can resolve a dispute. It doesn't have to be this one size fits all. Everyone must go to trial, or even everyone must go to mediation. Having a wider vision for how to resolve conflicts is the best we can do. Also, this is in 2026, the bar exam is going to undergo a big change. There's something coming. It's called the Next Gen Bar Exam. It's going to replace sort of the universal multi-state component in a lot of places, including Florida. And they're adding, the emphasis shift is towards more practical skills. And they're adding mediation. Mediation is going to be bar testable. I am super excited. So I think that is going to kind of raise the profile of this side of the profession. We call it alternative dispute resolution. It's not the alternative anymore. It really is sort of the default at this point in time, and people need to understand it well.
That's incredible. I did not know that the bar exam is going to start including mediation. I think that's really wonderful. And I really like your emphasis on how this is really a symbiotic relationship between a lot of different individuals, and really an opportunity, much like how you shared earlier, that mediation is a chance for parties to really have a driving seat. It's also helpful for other types of professions to learn from each other and gain knowledge in skills and communication that would otherwise look different in their own field. I think that's also what really attracted me to mediation. And just as you said, it's no longer alternative dispute resolution, but just dispute resolution. It's a really wonderful opportunity, I think.
I love, when you went, just to be clear, you also went to Nova, where I'm teaching now. And so Professor Frantatunic's mediation clinic there has cranked out a number of law students who have that love and that deep understanding of the principles behind mediation. And that's not available to every law student, and not every law student at a place will take it. It's an option. So I love that you got that. I love that you had that exposure, but it's not something that's really widely available throughout law schools. And I hope that it will become more so. It's tricky to kind of teach people, when you're sort of taught that you're the lawyer, the counselor, you're guiding the process to get people comfortable with that ability of, are you going to trust your client with some of these decisions? Can be really scary to attorneys, especially when they're earlier in their career.
And throughout your career, you have shared that you have had many hats and many roles. And I was wondering, as someone who has experience in program management, facilitation, and training, how are some of these roles influencing your approach to mediation? As we have said, that mediation is really multidisciplinary and it does attract a lot of individuals from many different walks of life.
So on the program management side, I think it made me organized enough to run my own business, which is so much of what being a solo neutral is. You know, maybe you're affiliated with a panel and you have a case manager, but that's not where most people start. If you are by yourself, then it's a very it's a very one-stop shop. So it's you're the webmaster, you're the bookkeeper, you're the marketing person, you're the everything, and you really want to stay on top of that. So I think that was really helpful to just be organized in terms of forms and processes and things of that sort. On the facilitation side, a lot of the facilitation stuff that I used to do is sort of diversity related. And so I had a lot of experience having difficult conversations that make people really emotional or uncomfortable or challenging assumptions and expectations. So that was really helpful, and that was a background I think that I brought in. And in terms of the training side of things, I love to teach. After a year at Nova, I'm really sort of deepening that. I've been training mediators. It's going to be 9 years this year, I think. I love that light bulb that goes off when people are like, "Oh, I understand that now," and just sort of giving people a piece of information that might be useful to them forever is awesome. It's a real high. It's just as awesome as when you settle a case, when help people settle their case, and they're just like, ah, we're done, it's over. That moment is that's the big payoff in mediation is watching that relief that it got, like the knot is untangled now. And so those two things are sort of emotionally connected, I think.
Sharing how much you love teaching, when you are training individuals, what are some of the core principles that you emphasize in your training programs?
Sure. I would point to two pieces, and I kind of refer to it as one of them is the compass for mediation. I think to me in mediation, self-determination is north. If you're not honoring self-determination, you're doing something wrong and it needs to be done differently. I think the grounding of it is the confidentiality side of things that allows that conversation to take place freely, informally, in private, right? For people to be transparent as possible in order to be effective. Which is not to say that people don't use negotiation strategies and tactics, but transparency can be incredibly helpful in terms of that mind shift from adversarial to more cooperative, collaborative kind of an approach. And then on the other, East and West are they are impartiality and neutrality. I took this from Greg Firestone. I love the way he explained it. Impartiality is the not favoring one person over the other, right? Working with each person on equal footing. And the neutrality is the idea that you're not picking options, right? You're there to help them generate options, but I was just talking about this in class the other day. I was like, if I'm holding broccoli or a donut, like, are you gonna? I can tell you should have a donut, or I can tell you should have broccoli, and lots of reasons why. But in the end, I'm offering the two to you, and it's your choice. You get to pick broccoli or donut, right? And so there's no correct or wrong answer here necessarily. It's just a choice. And so as a neutral, you don't put your thumb on the scale as to what's gonna happen here as an outcome. So that's the way I kind of explain the core principles of mediation. And the other one is I think that there's a real flow to the dynamic of the process. And if you know where you are during the process, you know exactly what it is that you're supposed to do. You don't get lost. And I learned this one from Perry Itkin, who I took my family mediation training with. It's a sort of theory of small group productivity, and it's the forming, storming, norming, performing, and adjourning. This idea that you come together and there's sort of all these dynamics there. The productivity kind of goes up a little bit, then you get to storming, and there's mediations that will crash and burn there because you never get past that real emotional kind of outburst stage where everybody kind of gets it all out of their system. But if they do, then you start making progress. You start getting to that norming of figuring out the parameters and laying out the issues, performing, laying down the details of what a resolution looks like, and adjourning, which means getting everything in the forum that it's going to survive that little bubble of a process and be something that you can pitch and sell to the rest of the people at home, or in the outside world. And so if you were to sort of like summarize what the whole thing is, I think those two concepts to me capture it the best.
And connecting to the principles that you shared with us from your own experience as a professional and training, what are some skills or traits that you have seen or believe to be are essential for mediators to succeed?
I think you have to, it's not enough to just be a good mediator. And to be a good mediator, I think you have to be a good listener. You have to be a good writer. You have to be a person who can draft what's being said if you're being asked to draft. And some people do, some people don't, depending on what they're practicing in. If you're sort of on the numbers side, you know, if you're sort of in that world where mediation ends with a stipulation, good with numbers and sort of a flexibility of valuation and what things are worth. And in order to survive as a small business, like you have to have some hustle in order to be able to do it. And you can't just sit there. It's not if you build it, they will come. You really have to go find yourself the sources of clients. And that comes through relationship building, because in mediation, there's, except for maybe the lawyers, there's not a lot of repeat clients unless it's an institutional client or an attorney, right? And those have their own complications as far as impartiality is concerned. But you're spending a lot of time hunting essentially for your next meal, if you will, for your next case.
Thank you so much for sharing those. I think that's really important and very insightful. I was also curious, in addition to some of these core principles, skills, and traits that we've kind of talked about, do you find that there are any common misconceptions about mediation that you think would be helpful in both practitioners and non-practitioners to know about? What is
One,
mediation? What is
I,
not mediation?
I wouldn't call it a misconception, because I think it's more of a difference of opinion in some situations, because there's a more facilitative style out there. And then there's sort of this more evaluative style, which I think is very appealing to people who have many years of experience under their belt and know all of the right answers. And so it's very hard to to keep yourself from telling people or even hinting at what those might ought to be. And there's a market for that. You know, some days, the way I ask people is, would you rather be told what to do or asked what to do? And most people will tell you they would rather be asked what to do. But there are some days and in some situations where the answer is just tell me what to do so that this can be done, you know? And so that to me is a component of self-determination. If people do want to be sort of told what to do, I think that there has to be room in the process for that. I don't think that we should get there by the lack of skills of a mediator who is just like, I'm just gonna not even ask you, I'm just gonna tell you, right? And Florida in particular, the rules in Florida are very facilitative. And so you are not supposed to tell people what to do. The ethical rules say that you're not supposed to do, to the extent that there are rules against things and you shouldn't do them. There's that. But is there a market for it? There's also some space for that. So I think that's the biggest one, whether it's the lawyer or the clients who are like, just please tell us what to do. That's kind of the biggest dilemma. And there are other processes for that. There's arbitration. You need somebody to tell you what to do, you get an arbitrator, right? It's not always possible. And depending on, some family issues, for example, can't be arbitrated, but there's a lot of stuff that can be. And if that's the inclination, then there's other processes.
And we are sitting here at the beginning of the new year in 2025. So I wanted to know from you, not only for this year, but for the future in general, what are some of the biggest opportunities that you see for growth in the mediation profession?
I think the COVID revolution, the Zoom revolution, I'll call it the Zoom revolution of 2020, if you will, really opened things up. Mediation has always been fundamentally a local practice about the people you know and the relationships you built locally. But I think being able to mediate virtually just opens the world. It does. I don't know how many people have figured out how to make that work. There's also international convention on mediation that's being signed now. So mediation agreements are reciprocal under this it's called the Singapore Convention, and so maybe that is going to open up more room, more space. As far as arbitration's been around for 100 years plus, but mediation is being in the courts maybe 40, right? So it's still kind of catching up that way. But I think the idea of being able to have sort of a broader market is a real opportunity. That's the biggest one to me. I think there's interesting stuff going on in online dispute resolution. And we'll see if they're, sort of the computer assisted mediation, if you will. I think it'll happen. There have been moments where people have tried it and it hasn't taken off, but I think somebody's going to figure out how to do that well. And it'll be interesting to see how we handle the competition from Chat GPT and so forth. And so that's going to be interesting as well.
You shared, I found it really interesting when you were talking about the Singapore Convention and having a little bit of an international component to mediation. I'm also curious in your thoughts, do you think we will also maybe see some national or cross-state line discussions of mediation? Yes. I know at the beginning of our conversation, when we were talking about certification for the state of Florida, Florida has certifications, but that might look different for other states. So where in terms of cross-state discussions will we see? Do you foresee that also being?
Definitely. And, in Florida, we have the advantage that our mediation program took shape in the early 90s, and it really was embedded in the courts very, very early on. Right now, New York is in the middle of creating their mandatory mediation structure now, like in 2025. So, and the conversation there has been sort of like, we like what Florida has, we'd like to do that, right? So places that are kind of, at one point in time when I first joined the ADR section of the Florida Bar, it was the 10-year anniversary of the section, and I went and I spoke with the different chairs of the past, and one of them was this man named Chuck Chance, and he was the chief judge of the judicial circuit up in Gainesville. And there were two of them, he and another judge at that point in time, and he's the first person in Florida who created an administrative order that made cases go to mediation before they went to see him or a jury for a bench or a jury trial. And his sort of narrative of how it was back in the day was people howling that you are, killing off our right to a jury trial, and this is a terrible thing. And then he sort of jokingly says, and all the people who complained back then are all getting certified as mediators now. He says, and at the beginning, he used to call it I think he called it a trial settlement conference. Like, he didn't call it mediation. He would mediate the other judges' cases and vice versa. And so there would be this kind of process where they'd sort of hand the power back to the litigants. We just weren't quite sure what to do with it at that point in time, until they realized what was going on. My international development background makes me look at where things live in an institution. And I think that those little details, like the admin orders and the judicial circuits, structurally open up the doors for what is the business of every mediator in the state of Florida today. Because if they didn't have to go, they wouldn't go as much. And so I think that opens a market. If there's more mandatory mediation, a movement towards that nationally, then I think that'll open up a lot.
And as professionals in this field within the state as well as nationally or internationally, are there organizations that help provide mentoring or connections for individuals that you know of?
There are, depending on the area that people practice in, there are always organizations that do it, right? Here in Florida, the ADR section of the bar, if you're an attorney, Florida Association of Professional Mediators, I think is what it is, FAPM, is both mediators and people from different professions. Attorneys and other professions as well. If you're in family, the Conciliation Courts Association, Family and Conciliation Courts, that's more of a national one. American Bar Association, again, is lawyer, but it's national. There's no one roster anymore, really. And the big big companies like AAA and JAMS are still more arbitration heavy than they are mediation centered. That's more their bread and butter, if you will. But there's a lot of resources out there. There's a lot of resources out there. Obviously, the Harvard program on negotiation has sort of the classic, education programs in there. And there's a lot of great training that's out there all over the place.
Thank you so much for sharing that information and those resources. Sometimes there are so much out there, so it's nice to have a little bit of an idea or a jump start of where to start looking for resources on this profession and where to start, which transitions into my next question. For anyone who is interested in considering a career in mediation or arbitration or dispute resolution in general, whether that be law students, new graduates, or individuals coming from other professions, what advice would you give those individuals?
If you're coming out of law school, I think it's tough to get employed as a mediator right away. My way through the courthouse is probably the best chance I had to do it when I first came out. I think of that as my clerkship, right? It was like a dispute resolution clerkship, essentially, while I was there. The benefit of I wasn't working by myself. I was working around lots of really experienced mediators, so I could just go down the hall and ask a question, as opposed to being on my own and wondering what I should have done. So that was a lot of what nurtured me coming up. It doesn't mean that I think people should wait forever to get a mediation training certificate, because I think the earlier you get that training, even the likelihood is that you're going to be an advocate in a neutral process as opposed to the neutral yourself. And if you understand it better, you can figure out that it requires a different approach from you than litigation does. That I think is important. And as far as shifting towards a more neutral practice or adding a neutral practice, if you develop that reputation as the person who's really good at solving problems and helping people untangle the mechanics of it, I think that lays the basis for being able to shift into more of that kind of practice. It can be a little tricky because if you're ever going to litigate against the people who you mediate for, they are unlikely to use you because they don't want you to see their tricks. They don't want you to understand all of their negotiation strategies if they think they're going to have to use them on you and not in front of you at some point in time. But there are still people who make it work. And some areas of the law are more collegial than others. Some areas of the law, everyone's like, yep, the shoe's going to be on the other foot. We all get it. Families like that. Workman's comp is like that. Dependency law is like that in some ways, where people are really very problem solving oriented, as opposed to areas where things are much more, and that it would be harder. It would be more of an either or situation in the more high conflict ones. So I think that's sort of a good place to start. I hope that helps.
Yes, absolutely. I think that's great advice. And my final question for you is, if you could go back and offer one piece of advice to your younger self starting in this field, what would you offer yourself?
I don't think I knew what the market barriers were at that point in time. And perhaps if I had, I would have done some things differently. I'm not entirely sure what, but I might have spent more time acquiring a specialty, maybe beyond what I was doing, and then sort of shifting, because I think that over time, that deeper pool of experience retains its value, right? And you can have that plus your skills as a neutral to rely on. So having gone straight into neutral work, I can't say I spent 10 years, in a particular field before. I spent 10 years in neutral world, but it's not neutral and. It's in one only. So maybe that would be something I might change. But I'm not sure what I would change, because if you change one thing, you can change everything. So I hate to undo it. It's been good so far.
Thank you so much for taking the time to sit with me this morning, Christina. I really appreciate your time. I have learned so much from you, and I'm really excited for our audiences to listen to our first episode this morning.
Thank you, Joanna. It's been an honor and a pleasure. Thank you so much for having me.
The Meet a Mediator podcast is a production in partnership with ADR Expo. If you enjoyed today's episode, please subscribe and check out more from ADR Expo at adr-expo.com. Thank you for listening.